All right, privileges. Listen, there is a lot of esoteric information in these chapters, okay? And some of it is testable, some of it is so esoteric as to not be testable. I'm going to guide you to the part that you need to know, okay? And for all practical purposes, everything in that handout that I just gave you contains everything you need to know from the 15 pages that is the Abuse of Legal Process chapter in the book, okay? So, privileges. Why do we call it a privilege?
It's not a right.
No, that's not why we call it a privilege. Why do we call the defensive to intentional torts privileges?
It allows you to do something.
It allows you to do something because defamation is an intentional tort, is it not, Mr. Cruz?
Yes.
So if we are privileged to make a defamatory statement, right, we are privileged to make that statement, right? It doesn't take away the defamatory nature of the statement. Y'all have got to get better at this. All right, so absolute privilege. Judges, in the conduct of their business, in the courtroom, as long as it relates even remotely to the issue at hand, okay, have an absolute privilege to say whatever comes to their lips. Look at the middle of note 1 on 975. Privilege attaches to the judge, the attorney, and the radio station upon the broadcast. The attorney's statement may be false and malicious, but will be privileged if relevant and pertinent to the issues in the litigation. The privilege covers preliminary actions engaged in by a lawyer in good faith in anticipation of litigation. For example, demand letters, negotiations, and file investigations. The privilege, note 2, the privilege extends also to witnesses, even though they testify voluntarily and not under subpoena. Look at the second paragraph in note 3. This is important. Once the privilege is found to exist, the only limitation on it is that what is said, the defamatory statement, must be found to have some reasonable bearing upon the relation to the subject of inquiry. Even the judge cannot seize upon the occasion of a judicial proceeding to voice entirely unrelated defamation. Okay? So, that militates against, right, the assertion of absolute privilege, right? But that's the way we still view it, right? Judges, attorneys, witnesses in judicial proceedings have an absolute privilege to say anything that comes to their mind as long as it relates to the litigation. Note 4. The result of the absolute privilege is what? There is no civil remedy at all against the witness who gives perjured testimony in court, even though he does so in furtherance of a conspiracy to injure the plaintiff. In other words, we haven't found a way to fix that problem. Legislative proceedings, okay, anything that's said on the House or Senate floor, absolutely privileged. Notice at the bottom in note 7, I've got note 4, note 6, and 7 circled. In the bottom of the page on 976, the Supreme Court held that the senator was wholly immune for his statements on the Senate floor, but not immune for statements in the press releases and newsletters because they were not, quote, essential to the deliberations of the Senate and were not, quote, part of the deliberative process. Okay? As long as it's on the floor, it's privileged. Hang in there.
So if a witness lies on the stand, that's okay?
Mm-hmm.
That's what that says?
Mm-hmm.
Okay.
Now he'll be prosecuted for perjury.
Okay. That's,
So in the Senate, if the senator says Trump has lied, that's privileged, but then outside the Senate floor, if they make that statement, and it's not true, then it's not privileged.
No, but then you go to, no,
No?
because that's what? He's a public figure
Oh, I'm sorry.
in a matter of public concern, right?
Okay, got
Yeah.
it.
What, you said, no 4 or 5, what else?
4, 6, 7. 8. And then we have some esoteric, esoteric rules in 11, 12, and 13 about federal public officials and state public officers. Okay, these are, those are small rules that you need to be aware of, where an absolute privilege applies. So what do we mean when we say by qualified privilege?
Whether you can print something
No,
or not.
right? If it's not absolute, then it's qualified. In that under certain circumstances, okay,
It protects.
one is protected from making, one is privileged, let's say it correctly, is privileged to make defamatory comments about another. Okay, primarily, and it can be a matter of public concern, it can be a matter of private concern between the two individuals talking about the third party. It can be a matter of concern to a third party, okay? But as long as it's made, as long as the defamatory statement is made in good faith, and it is made for those purposes, okay, then the privilege will stand. If one steps outside of that good faith and the purpose, and the common purpose, right, between the two or for the public good, then what? The privilege goes away, right? It abates, right? And it can't be asserted as a defense. So in Sindorf here, notice I've got 9. What are our facts here?
Brought a defamation action. Bad mouthing them.
Sindorf
His old employer.
worked for J. Crime, and basically I think he was terminated, and then he kept some inventory. Well, Allegedly, yes. And he was waiting on his commissions, and he didn't get those, so he withheld some product.
Right?
And he went to work for, it seemed like
It's important. Did he get fired or resign?
He resigned. Okay. Then he went to work with Toolbox, which is a subsidiary, and the vice president of J-Cron had a relationship with the president. They kind of were friends and knew each other, so they got to talking, and he made some statements to the president of Toolbox and told him he better watch his inventory closely. The trial court granted J-Cron's motion for a direct verdict, but then when they appealed, the judgment was reversed and remanded because the rule of law is a conditional privilege to make a defamatory statement is lost when the speaker abuses it. And they felt like
There
he
you go.
abused it because he couldn't prove that.
The privilege is lost when the speaker abuses it. And there are factors here to be considered. We'll get to that in a second. The bottom of 978. This is great language if you're presented with a essay question in defamation for a rule. In an action for defamation, the plaintiff's prima facie case is made out when he has established a publication to a third person for which the defendant is responsible, the recipient's understanding of the defamatory meaning, and its actionable character. It is then open to the defendant to set up various defenses, which to some extent have moderated the rigors of the law of libel and slander. I've got 979 circled. Conduct which otherwise would be actionable is to escape liability because the defendant is acting, quote, in furtherance of some interest of social importance which is entitled to protection even at the expense of uncompensated harm to the plaintiff's reputation. Further down, the quote, in the words of Baron Park in Too Good, a publication is conditionally privileged when it is fairly made by a person in the discharge of some public or private duty, whether legal or moral, and in the conduct of his own affairs and matters where his interest is concerned. Further, interest of the publisher, interest of others, common interest of publisher and recipient, communications made to one who may act in the public interest and fair comment on matters of public concern. As Mr. Cruz pointed out, as long as that is true, privilege to make the communication, to make the defamatory comment. But if those motives, if you step outside of that, you lose it. Notice whether the occasion was a privileged one is an issue of law. Unless the facts are in dispute, then it goes to the jury. That's in the following paragraph. On 980, you have a list in the third full, in the paragraph beginning, because a conditional or qualified privilege is conditioned upon publication in a reasonable manner for a proper purpose, it is defeasible. That means it can be defeated, or it can be lost, or it can go away. And there you have a list. In determining an abuse of privilege, all relevant circumstances are admissible, including the defendant's reasonable belief in the truth of his statements, the excessive nature of the language used, whether the disclosures were unsolicited, and whether the communication was made in a proper manner and only to proper parties. And then here's our word again, malice. That just means not necessarily with ill will, but for perhaps, Sullivan malice. Reckless disregard for the truth. Here, what were our factors that militated against the defendant?
He was pissed off that he went to work for a competitor.
Right. And he initiated the contact.
Right.
Right. And then he said he indicated that the guy
Was a thief.
had been fired when in fact he had quit. Right. So all of these things taken together, right, a reasonable mind, a reasonable jury could disagree about the proper purpose of the defamatory comments to begin with. So it was wrong for the trial court to have kicked it on a directed verdict. I've got note 1 circled on 981. Person has a qualified privilege to make defamatory statements in a reasonable effort to recover goods stolen from him. Give me an example.
Like if somebody's standing in front of you and they take your stuff, you can get it back in. You can't go get it later.
No.
Sorry.
Mr. Headley.
Well, you can't make a statement that somebody has committed a crime. That's right. That's defamation. But in this case, if it's a crime against you, I guess, for stolen property, is that what you're getting at?
Yeah, well, like, in what circumstances might I make a defamatory comment about somebody else to recover my own property?
If you were convicted of theft, and I just
I
said
like
it,
to call you and say you
No.
stole my stuff.
If I'm trying to recover my own property,
If the employer,
did y'all read this?
There's examples in the note. An employer accuses one employee of 4 others of stealing from him.
Thank you. Thanks. Is there a better? I wanted to read the book. I would read the book.
at least we're here.
All right, go with that one.
So what does that mean? You can call somebody up and call them a thief in order to get them to bring it?
What, right. Like,
but what if they accuse you of something and you didn't do it?
well, then you don't have the privilege, right?
It's like,
Notes 2, 3, 5. Note 7 is important. Courts all agree that the defendant cannot claim a qualified privilege if he knows his defamatory statement is false or does not believe it to be true. Majority rule. Courts all agree. Okay? And to take note of 10, with fair reporting, it was in the notes last week. Pay attention a little bit, or reread fair comment. Notice about 2/3 of the way down, the privilege might be abused and lost if the criticism did not represent the actual opinion of the critic or if it were made solely for the purpose of causing harm to the person criticized. Don't worry about the next section. Damages on 994. Remember, for libel and for slander per se, it was presumed in common law that there were general damages. Okay? For slander that is not slander per se, we have to prove what? Special damages. Thank you. Okay? Note, and I mentioned this earlier, in the middle of 995, the libel proof plaintiff, it is possible to have such a nasty reputation that one can be libel proof.
How bad is bad? I mean, how bad you gotta be to, like, if you're a prisoner?
Talk about like,
I mean, even prison, is Paul Manafort libel proof? No. Right? No.
like a serial killer?
I mean, now you're getting closer. Right? Jeffrey Dahmer libel proof? Probably. Yeah, he's dead. Somebody like that, though. Anybody convicted of child sexual abuse? You're getting there. You know what I mean? As the notes say, there was the one gentleman that was Plaintiff was, the court found, a convicted racketeer, mafia associate, bank robber, and drug dealer. An unsuccessful prosecution did not rehabilitate him. Right? That's pretty across the board. Yes?
So it basically has to be strong enough. It can't be something like, oh, she's or he's, a rude person. Like, it has to be extreme.
Yeah, it's got to be extreme. He's a womanizer. Right? Not going to get you there. Yeah.
Now, is the company responsible for what the employees say?
Think about what you just asked me.
Well,
Think about what you just asked me. Why would that not be the case?
don't they represent the company?
Eh? What did we just talk about? Hang on, don't blurt anybody. What did I just say to him?
Slander.
What did I just ask him at the beginning?
Slander per se.
Defamation is. Hang on, Mr. Francis.
Special damages.
Thanks. Hang on. Come on, stick with me. We were talking about privileges, right?
Right.
Privileges apply to.
You can apply under certain.
Privileges apply to.
Public.
Defenses to. Privileges or defenses to.
Defamation.
Yes, because defamation is an. Stop blurting. Is an.
Intentional tort.
And are companies generally liable for the intentional torts of their employees?
Only in the scope of business.
Generally, that's a yes, no question.
No.
Yes.
Thank you. Now, what was over here?
Me.
Yes.
When I was reading this, there's a section here on mitigation of damages. Provocation by the plaintiff is generally regarded as admissible for the purpose of mitigating the damages. I couldn't think of when that was.
Well, if without a better example, let's say male A is sleeping with male B's wife, okay? And male B calls male A, you know, a whoremonger. All right? It's not, you know, you don't have to think broadly on these things. The incremental harm doctrine is interesting. I have never seen this tested, but look at the first full paragraph of 996. This is from Uncle Antonin. The theory must be rejected because it rests upon the assumption that one's reputation is a monolith, which stands or falls in its entirety. The law, however, proceeds upon the optimistic premise that there is a little bit of good in all of us, or perhaps upon the pessimistic assumption that no matter how bad someone is, he can always be worse. Okay, he was a liar and a thief, but for all that, he was a good family man. Who does that make you think of? Who? Trump. Is Trump a good family man? I don't think so. The reporting says differently. Who does that make you think of, though? Seriously, read that again. Everybody look down and read that again. And tell me who you think that applies to. Who did we fall in love? Who did the American public fall in love with in like the early 2000s?
Garrett from Subway.
No.
Tiger Woods.
We didn't know anything about Jared from Subway.
Tiger Woods.
No. It's a character. I'm thinking about a character. No, that was in the 80s. They were really in the 70s. But you weren't even a Twinkle and Bill Cosby. Think of a character.
Al
Who was
Bundy.
a very bad guy.
Al Bundy.
No. Tony Soprano. Right? He was an awful person, but everybody would watch that show, and we generally liked Tony Soprano. Even though he was a murderer and a thief, he killed several people before our eyes, and we would tune in the next week to see what kind of was going to go on.
All for the great good of his family.
All for the good of his family, right? After all, he was a good family man.
Other than she makes wife.
I mean, same applies to Michael Corleone, right? Godfather. Who said who?
Any of the mall scenes, I think about
All right. Here we go, 996 at the bottom. Bad reputation. Evidence of a bad reputation may reduce the damages the plaintiff can recover. Okay. But notice evidence of particular facts tending to establish the plaintiff's reputation is inadmissible. Okay? And there are ways to establish bad reputation, including rumors. Rumors are admissible if shown to be sufficiently widespread to affect the plaintiff's reputation. Punitive damages, okay? Second sentence. It seems clear that in the absence of malice in the constitutional sense, the Sullivan malice, right? Knowledge or reckless disregard as to falsity, they cannot be awarded. The section on nominal damages tells us that the Supreme Court has yet to rule on this, but one may seek declaratory relief, okay, to vindicate one's reputation.
So, I thought I read that, maybe I read it wrong. If there's actual injury, then they could get nominal damage?
No, that's in Gertz, right? The plaintiff cannot recover unless he proves actual injury. If we have actual injury, then what? Pleasure. Then the jury can put a number on it. All right? If we have actual injury, the jury can put a number on it. mean, it's awfully expensive to prosecute it. Would be awfully expensive to prosecute a defamation action for either nominal damages or declaratory relief, right? Because, I mean, but, I mean, if you're a private individual with a lot of money, right? Well, either way, it just doesn't make a lot of sense, right? Well, that was defamatory. My feelings are hurt, right? So I'm going to hire somebody at $450 an hour to go get a declaratory, judgment saying that, oh, you shouldn't have said that. Bad person. Number 3, self-help. The first remedy of any victim of defamation, right, not a DEC action, is using available opportunities to contradict the lie, correct the error, and thereby to minimize its adverse impact on reputation. Retraction is important. Notice, right, if newspaper publishes defamatory material, if the plaintiff calls the newspaper and says, you need to take that back, that's false, okay? And then, depending upon the severity of the defamation, okay, if they don't retract it given a certain period of time, it may become intentional, and then we start talking about punitives, okay? I have seen that come up.
Now, where they print the retraction, though, may not be in the first place that they printed it, right? Like, the story breaks on the first page, but then a retraction can be on page 12 in the back and a very little
Right?
excerpt.
I think that qualifies for the last sentence on the page, right? Indeed, an evasive and incomplete retraction may be grounds for punitive damages. Notice at first sentence of note 4, prior restraint of a publication runs afoul of the First Amendment. In other words, if someone knows something is coming out and goes and seeks a preliminary injunction, okay, you can't stop them from publishing it. You can sue them after it comes out, but you can't stop them from publishing it under the First Amendment.
That's a Big Lebowski ground.
Hmm.
Big Lebowski, Supreme Court ground rejected prior restraint.
Yes. You're confusing me. I don't think I know what you're talking
You know what I
about.
mean?
I've seen the movie, but I haven't seen it that as many times as some folks have seen it. Okay, privacy. This comes up on the bar exam, but it's a very small portion of what comes up on the bar exam. You need to be familiar with about 8 things here. First of all, you got to know the 4, all right? The 4 types. There are really 5. Appropriation, intrusion into seclusion, publication of private facts. What's the 4th? False light, which is really just the little sister of what? Defamation. Okay.
Can you read that again? I'm sorry.
Do I have to repeat them again? That's the whole chapter.
I know.
Appropriation, intrusion into seclusion, publication of private facts, and false light. So,
That disclosure, publication of private facts,
yes, publication of private facts.
that's disclosure, right?
I call it publication of private facts. Okay, so at the top is Joe Dickerson. I like this case not for what's necessarily for what's in it, but the way that it's laid out is a very concisely written case. I would read it again just to pick up on some hints on how to talk about this, what's on the board over here. Okay. But under Colorado law, top of 1003. Look at that, 1,000 pages, everybody. Give yourself a round of applause. She looks like she's read 1,000 pages. Did you read them all last night? You okay?
No.
I'm kidding.
Slept last night.
Oh, good. I did too. All right. Elements. 1, the defendant used the plaintiff's name or likeness. The use of the plaintiff's name or likeness was for the defendant's own purposes or benefit, commercially or otherwise. 3, the plaintiff suffered damages. And 4, the defendant caused the damages incurred. This use may be privileged under the First Amendment, and that's what primarily the rest of this case is about, right? What has happened here? Dickerson is using the plaintiff's conviction for stealing folks' bearer bonds. The plaintiff was convicted, okay? And so we have a commercial speech issue, right? And we have to address whether, whether the plaintiff's reputation had, or name or likeness or whatever had value before the publication. And the court says, what about that?
It did not.
Huh?
The court said it did not.
It does not have to have a certain pecuniary value in order for the case to move forward, at least in Colorado. So the court very succinctly, 2/3 of the way down on 1004, lays out the 3 issues for you. There are the list that, on 1005, in the 1, 2, 3, 4th full, William Prosser described invasion of privacy as a complex of 4 related torts. There they are, Marlana. 1, unreasonable intrusion upon the seclusion of another. Publicity. 2, publicity that places another in a false light before the public. 3, public disclosure of embarrassing private facts about another. And 4, appropriation of another's name or likeness. Find it? Y'all with me?
Yes.
The problem with appropriation, and this is where it gets testable, is that there's one part that applies to the as it says, personal interests, and one that applies to public interests. Okay, and that's called we have a right of privacy and we have a right of
Publicity.
thank you.
You're welcome. One time.
Publicity at the top of 1006. The right of privacy to keep your likeness and because it's a reputational thing, right? Remember the lady in the defamation case, early in the defamation chapter, it was like in the 20s and she was a nurse and her photograph appeared on the cover of a liquor bottle, right? That, I mean, not only if they recognize that appropriation, that goes false light as well as appropriation, okay? That was her, and she was not famous, and so her reputation was at risk. Here, our right of publicity, right, applies to our economic interests in our image and our voices and our words, okay?
Hey, did you see the memes about the girl at the one of these award shows that was standing there holding the Fiji water in the background, one of the,
I have not seen that.
well, that's what this is. I mean, she sued Fiji, like she was paid by Fiji to stand there and give all the stars water, but her likeness was like, you know, reposted on Twitter and Facebook and all that, and she sued for.
There were memes?
Oh, it was
Well, what
everywhere.
means, yeah. But she was in a blue dress like
It's
the
okay.
other.
I live in a cave.
You won?
No, what
I
now?
don't know, it just happened.
So she's standing behind some celebrity
She was
with
one
two
of-
bottles of Fiji. She was paid by Fiji to do that.
She was like one of 6 models in blue dresses standing there holding the
Look.
tray.
It's going a little bit further than that. Wasn't she kind of photobombing them?
Look, this is.
Yeah, I know.
And it ended up everywhere, like every celebrity, she's standing back there.
And so now she's suing Fiji?
She was paid to give out the water, but she wasn't paid to be like a real Fiji for advertising and stuff. They were
She
getting all
just
this.
saw an opportunity and took it.
Yeah.
They sued.
We'll see how that turns out.
Yeah, I mean,
Track
it
that
just
one.
happened,
She
so-
knew she was gonna be photographed.
She was in a public.
Because like right here, she's like.
Right, she's in a public place. She's photographing a public place.
She's just trying to get 15 more minutes of fame, that's all.
Look at, okay. Okay. 10:07, third full. In the context of damages intended to remedy a proprietary injury to the plaintiff's commercial interests, it may make sense to require a plaintiff to prove the value of her identity, either as part of her proof of damages or as an element of the tort. This does not necessarily mean that the value of the plaintiff's identity is relevant when the plaintiff seeks damages only for her mental anguish. Gesundheit. And then there's the discussion of the newsworthiness privilege and the First Amendment in Section D. In the argument. But this is covered more in your constitutional law class, so I'm not so concerned about this.
You don't pay attention to this part right now?
Yeah, you don't have to worry about that part, the First Amendment part, for purposes of that particular First Amendment argument for purposes of the exam.
Thank you.
Second paragraph, note 1, 1010. The use of the infant's photograph. Okay, was the child's image appropriated? Yes, but it was so cute. There was very little damage. And there it is, note 4, 10, 11. Circle, circle, star, star. Right of publicity. Okay, so this is akin to what?
Privacy.
What if I sued for an appropriation under a right to publicity? What is that like? What does that sound like to you?
Conversion?
Huh?
Conversion?
Right of
I can't hear you.
I say conversion.
information.
Well, it is a conversion, but it's a different type of tort, right? But what does it sound like?
First Amendment?
No. Well, yes. I'm suing on appropriation, and I'm stealing somebody else's, and I, as a defendant,
Identity.
am using somebody else's, or using somebody else's voice or appearance. I mean, we've got a robot that looks like Vanna White, for heaven's sake. What does it sound like?
Identity theft?
No.
False identity.
Intellectual property.
Yes.
What?
Intellectual property, copyright. This sounds like copyright law, right? I have a proprietary interest, if I am famous, in being able to control access to the use of my image, my voice, my creations. Okay, that goes to intellectual property. All right. So, who does the Ram truck commercials? Do y'all know?
Sam Elliott.
Well, Sam does some of them. No, not Mike Rowe. Close. Maybe I have the wrong truck. Dennis Leary does them, right?
Oh, he does the Ford.
Oh, he does the Ford?
You don't even know.
I don't even know. I was thinking the Ram truck. I know Dennis Leary does one of them, right? So, if they hired somebody that just sounds like Dennis Leary to do those commercials, right? Dennis Leary has a right to the sound of his own voice. Who knows who Tom Waits is? Anybody? Tom Waits? Tom Waits is a very distinctive voice. And so Tom Waits won one time in one of these actions because somebody made a commercial that sounded like Tom Waits doing a commercial. But it wasn't Tom Waits. They got it on the cheap. And he made him pay for it. Who else can you think of that has such a distinctive voice that
The guy that plays the orange bagels.
Morgan Freeman.
Morgan Freeman? Well, see, the problem with that is you can't repeat that. That thing's so good, you can't find anybody to fake that. What's that? Samuel Jackson, I agree. Sam Elliott, I agree. James Earl Jones. Okay, so you get the idea, right? So, there we go. Look at the next paragraph. Second paragraph, note 4. Thus, at common law and under California statute, causes of action have been stated for advertisements that use a well-known race car driver's car to promote cigarettes. A sound-alike voice, apparently that was Bette Midler. A robot redolent of Vanna White. And a birth name of a famous athlete. Somebody used Kareem's, Lou Alcindor. That was his given name. There's a case where Carson v. Here's Johnny Portable Toilets. Too bad. Okay, so they give you all, you're given all these examples. Just understand the difference between the right to privacy and the right to publicity. Okay? In note 5, we're told that a property right survives the death of the person.
Dean Garrett,
Yes.
could you explain this to me? A couple weeks ago, I asked about Michael Jackson and his estate.
Mm-hmm.
And then with the new HBO special, and he was tried when he was alive and found not guilty of the sexual abuse of the children. But how does that? You can't sue for defamation when you're dead. How does it work when
He is a public figure.
Okay.
And it is a matter of public concern. Okay? So it's open season on Michael Jackson. Right? He is a universal public figure even in death. Right? He is the king of pop.
So when his estate hits a slump on music sales or radio not playing his music, there could be a cause of action because he is the public figure.
No.
Okay. I'm confused.
He is newsworthy.
Okay.
That is a documentary about a public figure and a matter of public concern. They're not going to, those people, they didn't need permission to make that, right? He's not starring in that. That is a documentary, that is news.
Okay.
About a dead person. That dead person doesn't have a cause of action in defamation. His estate doesn't have a cause of action in defamation. As long as they don't defame, what are the kids' name again?
Macaulay Culkin.
No, the kids, Michael Jackson's kids.
Yeah, Blanket.
Blanket, yes, I love that one. Blanket. Okay, as long as they don't defame blanket in the process of making this film, then there is no cause of action.
Okay. Thank you.
You're welcome.
So is it safe to say there's no private life for public figures?
Well, there is private life,
In
there is
their
a
own
line, right? I mean, sure. I mean, there's a book out there, and I studied it, well, put my sociology hat on, there's a couple of books, a few. You can look them up. It all started with a guy named Irving Goffman, and it sort of relates to Marshall McLuhan and the proliferation of electronic media, and we sort of hit the wall, and there was folks like Goffman. There was a really great book written called No Sense of Place by a guy named Joshua Meyerowitz back in the early 90s, and a guy named Neil Postman wrote a book called The Disappearance of Childhood, and it's about public and private. Goffman started with public and private behavior and public and private spaces, right? And what Postman ended up saying, this is a very thumbnail sketch, is that as we're watching television, right, we run out of plot lines because we run out of front stage behavior to watch, right? And so television, although it started getting what? In the late 70s, right, we turned to shows like All in the Family, right? Where all of a sudden you're hearing the first toilet flush ever on television was on All in the Family, right? And so we're moving from Ozzie and Harriet and Leave It to Beaver to, what was his name? All in the Family. Archie Bunker, yeah. Archie Bunker and flushing the toilet and calling everybody a meathead. And then the next thing you know, we're, now what do we have? We have reality TV. Like there are no hidden spaces anymore as far as what we're able to watch. We've hit the wall such that now we're broadcasting ourselves in private, sometimes in certain situations on Instagram or Snapchat or whatever. To your point, there is almost no private life, right? There is almost, some folks broadcast very private moments on Instagram and Facebook and all of that other stuff. And, and it's astounding to me to see the things that some people want to broadcast to the world. That said, now there are lines, even Kim Kardashian has a line, right? I think. I'm not sure where it is, right? But there's got to be, as far as someone else, talking about what Kristen's talking about, as far as someone else poking their nose into her business, right? She releases a lot of stuff on her own, and to the point where, there's not much she hasn't done, right? Calling her a liar might not, to Davidson's point about sort of libel proof, right? But you see what I mean? Is it too much? No. Okay, so with these universal public figures, and even and I understand where Kafka's concerned about the acquittal, right? That's a matter of public concern, and Michael Jackson was out there forever, and I don't think there is a line, especially since he's gone, right? I'm having trouble thinking of folks that I want to talk about. Beyonce. Jay and Beyonce are maybe universal public figures, but they definitely have a line that you can't get into their stuff, right?
When they hacked, like Jennifer Lawrence and a bunch of them, they hacked their cell phone private pictures.
Oh yeah, sure, right? That's a line, absolutely. That's conversion and all sorts of different things. Appropriation, conversion. We could have fun with that one, right? That'd be a long complaint. So here's a line for you in Sanders v. ABC, right? And the issue at the bottom of 1015 is whether a person who lacks a reasonable expectation of complete privacy in a conversation because it could be seen and overheard by coworkers but not the general public, may nevertheless have a claim for invasion of privacy by intrusion based on a television reporter's covert videotaping of that conversation. The answer to that question is
Limited.
yes. Okay, yes. It does not, the law does not require, all right, for the intrusion upon seclusion that the defendant or the plaintiff be entirely alone or in a closet, right? Or entirely alone. There can be a limited number of people around that also overhear the statement, and there still be a cause of action in intrusion. Second full paragraph, 1017. On further consideration, we adhere to the view suggested in Schulman. Privacy for purposes of the intrusion tort is not a binary all or nothing characteristic. There are degrees and nuances to societal recognition of our expectations of privacy. The fact that the privacy one expects in a given setting is not complete or absolute does not render the expectation of unreasonable as a matter of law. Notice that case, I have seen the Husky v. NBC at the bottom of 1017. I have seen that in a bar exam question. Okay? The fact that he can be seen by others does not mean that one is not secluded. And notice this case also mentions DeMay v. Roberts. We have read that case. That was the case where the young man who was not a nurse entered during the childbirth. Remember that one?
Yeah. Just an outsider.
Good sentence, second full, 1018. Privacy for purposes of the intrusion tort must be evaluated with respect to the identity of the alleged intruder and the nature of the intrusion. Have y'all seen, speaking of things that came out this week, did y'all see that thing where some hotel, I don't know what hotel it was, there were 1,600 instances, they spied on 1,600 guests? Huh? It was in Korea? Woo!
I saw a thing where they're talking about Airbnbs having videos in them. Like people putting them up.
That's a good reason not to sleep in somebody else's house. Majority rule, top of 1019, more particularly, none hold or demonstrate that a worker necessarily loses all reasonable expectation of privacy against covert videotaping merely because the worker's interactions and conversations may have been witnessed by some coworkers. So that sort of language is repeated throughout this case. That's what you need to take from this one. Note 1, physical intrusion upon seclusion or solitude has been recognized as a distinct form of invasion of privacy. Right? Physical intrusion, coming into the room. Okay? Onto the sun porch. And then we have notes on eavesdropping, the bugging of a tenant bedroom, telephone harassment, repeated obscene phone calls may create a liability for IIED. Notice in Note 3. Note 3 deals with the difference between this And defamation, right? There need not be publication of anything taken while within intruding upon the seclusion. The intrusion itself makes the defendant subject to liability, even where there is no publication or other use of any kind of the information. The second element in note 4, star, circle, circle. The intrusion must be into a private place, conversation, or matter, and 2, must be highly offensive to a reasonable person. And 2, must be highly offensive to a reasonable person. So we have an objective standard, okay, of high offensiveness, great offensiveness, that we insert in here in order to complete our prima facie cause of action.
Dean Garrett?
Yes?
If the person changed depending on, like just say it was something for religious purposes, like to a reasonable person who isn't in that religion, it wouldn't be a big deal, but to them it is, then would that factor go into play?
Yeah, I would say that would come, that's admissible as to play upon the damages, yeah. Okay. Because if, say, on the grounds that what? Any offense to one's religion would be taken as by a reasonable person to be reasonably offensive, right? What? Okay. We're not talking about an unusual sensitivity, okay? Unless it's really, really ticky-tack. Yes. Green, did I see you raise your hand? Or you stretching?
Yeah, that's just a. Sorry.
Ordinarily, note 5. I've got all the notes on 1021 circle. Ordinarily, no liability for taking the plaintiff's photograph in a public place, which goes to our FINA girl. Okay. Not only was she paid, she was in a public place, and she was photobombing. All right, let's go back to appropriation for a second. I have to ask this question because I think your responses are interesting, and I don't know how this thing turned out. So remember that a few years ago, in the convenience stores, they would have those mugshot books. Like everybody got picked up over to a certain area over the weekend, got the mugshot in the little newspaper.
Now they have the app.
All right, they still have them?
Yeah.
I'm surprised.
No, now they have the app. So,
Okay.
just look at this.
What's that?
That's the app.
The mugshot app? Oh wait, there's a mugshot app. All right, stay with me. Okay, so they can publish that on grounds of what?
It's a public.
Public knowledge, things of public knowledge, right? And so they're profiting on things of public knowledge. Now, all right, one of them decided to publish the same thing, but they had a special section for the hottest top 10 mugshots of the week, right? And then they ranked them.
I've seen
Okay.
that online, but I haven't seen that.
What's that?
I've seen that online, but not on.
They did that with
So, in one of these, a lady in Florida who appeared, she was number 1 for the week, okay, sued for appropriation.
Wasn't it appropriation in both cases? I mean, like.
Huh? Wait a minute. Here's the question.
Okay.
Do you think that by qualifying the image, okay, and ranking them, right? Does that change the public knowledge? Does it change the argument?
Now it's entertainment purposes and not.
Now that's right. So what if there were at the end of the year there was a compilation and they republished all of those hot mugshots? Okay, does that changes the argument? Doesn't it not?
Yes.
Okay. I don't know how it turned out. I think they settled.
The movie, the social media movie about Facebook, how it got started. He hacked into like Harvard and different.
It was like Face Match or something.
Right.
To their school databases, and he would put girls that from their student picture, hot or not, and made an out from it.
Yeah,
That's how he got started.
I wouldn't do that.
I mean, but I don't know what, he got sued for it, I don't know what happened.
I'm sure he can afford it.
No, this, yeah, I mean, it's before he got.
Yeah, Green.
So, I think me, working law enforcement, I think that would be kind of subjective because every week we put people on Crime Stoppers and,
But that's a public concern and for a public purpose.
Right, but I'm saying we have a top, or we have like a Manhunt Monday and one of the, where we publish onto the news, hey, we're looking for these 3 guys, they're horrible people.
But those, you're not.
Okay.
Hot or not,
Yeah, hot or not is not. You see what I mean?
I get what you're saying.
You got public enemy number 1, right?
But whether he's hot or not, is it okay?
Yes.
That would open the book for, and I know people have fun doing this, but when you look at the old mug shots of people that have gotten into meth and at one time they looked really good and then all of a sudden 10 years later, 5 years later, they look horrible, that person could still sue in the same way on the same grounds, but not under the top 10 hot, but kind of the worst meth one.
Well, okay, but I mean, if you're talking about the textbooks, I'm just saying it changes the public interest. What?
Yeah, people.
I didn't know that was an official publication.
It's
Well,
a website.
if typoed up on that thing, somebody's going to hear about it. Yes, ma'am.
I just have a question about the intrusion. There's an invasive test with the 2 elements and so on. But and you talked about the cell phone tapping and those kind of things. If it's done by law enforcement for different reasons, are we on a totally different spectrum?
Wholly different spectrum. Okay, wholly different spectrum. I mean, then if you're doing that, I mean, that's criminal procedure. That's not torts, right? That's where you got a wiretap. I mean, where you got a probable cause and a warrant and
But if
everything
you're
else.
in the conversation, you can record it, right? If
Okay,
you're
that's
in
state
the
specific.
conversation.
That's state specific. Alabama, you can record. California, you cannot without asking
people
permission.
knowing.
What?
Without
You're
anybody
right.
knowing.
Yes. Y'all need to stop asking questions. Read more. Go.
Well, this one's a little bit more, I guess. So if you go to a store, right, and they think you stole, you know how you have those places where they'll take a picture of you and they'll post it and say, don't let this person in the store because they've stolen, but they don't have proof. You can get sued for that, right?
That's defamation. That's not privacy. If that's not true and you can prove that it's not true, that's defamation.
So you have to prove it.
Yes, go back to your chart. I gave you a chart. Yes, you would have to prove it. Yes. What's that? Go ahead.
I was saying they have a record.
Yeah. All right, Hall v. Post. This is this case where the lady came back after several years and was looking for her daughter who she'd given up as an infant. And this is public disclosure of private facts, right? And why did the court rule in the defendant's favor here? First of all, North Carolina doesn't even want to recognize the cause of action, right? Right. Okay, North Carolina refuses to recognize the cause of action for various reasons. I've got 1024 circled. Notice we have a I've got 1024 circled. In the first inset, we restate the 4 causes of action. In the second full paragraph, under the restatement, the definition of private facts will be liability when imposed for publication of private facts when the matter publicized is of a kind that, one, would be highly offensive to a reasonable person. There we have another highly offensive element. And B, is not a legitimate concern to the public. This definition includes 4 elements: publicity, private facts, offensiveness, and the absence of legitimate public concern. Okay? That's what you need to know about this particular tort. Here, North Carolina refuses to recognize it, reasoning that it overlaps too much with defamation law or existing claims for relief for IIED and others. Okay? Justice Fry on 1026 concurs in the result but disagrees with the court, the majority, that North Carolina should recognize the cause of action. But here, the court, the concurring Justice Fry realizes that, or reasons that what? This is a matter of public concern, and therefore there is no the plaintiffs would not prevail in any case, even though they are private people. Note 2 on 1028, cases suggest that disclosure of an embarrassing private fact to only one or just a few persons does not amount to an invasion of privacy. Look toward the bottom of the page, paragraph, about 5 lines up. It is not an invasion of the right of privacy to communicate a fact concerning the plaintiff's private life to a single person or even to a small group of persons. Yes.
So when I read this case, I just sort of felt like I couldn't understand why it was of interest to the public. It seems like a very private matter that wouldn't have been in the public realm had the journalist, had the media not made it something that was in the public realm, if that makes sense. I mean, I think,
no, a woman coming back and going to the authorities in the town and saying, hey everybody, yo, I was here some time back, I left a baby, who's got it? That's a matter of public concern. I disagree.
But for the other side. But for the other side of that issue. I mean, that's only one side of the issue.
I don't understand what you're saying. They responded, somebody went to the woman that said, hey everybody, that's a news story. That concerns a small town. That's a community story.
Okay.
I mean, that to me, I don't see where you're going with that. As the court says at the bottom of 1027, however much plaintiffs may have wished to keep their personal histories out of public view, they became a legitimate public concern upon Gottschalk's return. There are times when one, whether willingly or not, becomes an actor in an occurrence of public or general interest. Note 3, one who intentionally seeks publicity has no right to complain of publicity that reasonably bears upon his public activity. Notice that second paragraph in Note 3 talks about limited public figures. sometimes unwilling limited public figures. Pre-esoteric is the common law action for breach of confidence. That is note 4 on 1029 and 1030. I would read that. Note 5, if the information is in public record, there's nothing to protect. Next paragraph. Even confidential information may be disclosed to appropriate parties on occasion. In note 7, I looked at that case. That's a yes. That is a publication, the placard. Check that out. Check note 8 out, BJ. Bitsy v. Walston holding the traditional beliefs of the Navajo about taking a child's photograph were not sufficient to make the action highly offensive where defendant newspaper did not know of the beliefs. To your question earlier. And note 12 mentions the case in the Florida Star, the Florida Star. Once something reaches the public domain through lawful means, the media can publish it. Without it being an intrusion or a disclosure of private facts, excuse me.
That still doesn't give us about the right publicity, it's just saying it's non-intrusion. Like if they're making money off of money box.
Right. In Cantrell, what we have are we apply the Sullivan Malice standard to the invasion toward false light. And in this case, the writer and thus the newspaper had made false representations, knowingly and materially made false representations about the plaintiff and her family after the death of her husband, indicating that they had interviewed her when they had not, and other such misrepresentations. So, there's not much more to that case, to this case, than that. Placing the plaintiff in an objectionable false light in the public eye, right? Taking my picture in front of an Auburn flag. Just kidding. Just kidding. Hey, good luck tonight, guys. Hey. And nice win last weekend.
Thank you.
Congratulations. No kidding. That's a big deal.
Are you being facetious?
No,
Us
I'm
winning
not
by
being
1
facetious.
point against New
Can you
Mexico
not hear the sincerity in my voice? No, I mean it. That's a big deal. I mean, that's great. I mean, y'all have won that. I mean, I don't know when the last time we won it was, but y'all have won that thing since Chuck Person.
Oh, that's another thing.
I was 15. That's how long ago that was.
But you're not talking about Thursday's game. We only won by 1 point.
No, I'm talking about the SEC championship win. Right? It's all from here on out. It's all gravy, baby. Y'all win two more. You're in good shape. We're in the market for a new coach. Hustler magazine deals with a lot of deals with First Amendment issues, right? Notice here that the Reverend Falwell is suing for what? What's that? No.
IIED.
No. He's suing for IIED. Why?
Because
That's
there was
mama.
articles of him in that magazine.
You're talking about
This is a parody that showed him in his.
Stop. Why is he suing for IIED?
because he's a preacher.
Because he had emotional distress.
Because he's a,
Because he's a preacher, suffering from.
that's part of it, Mr. Hodges.
The publication didn't say what it was saying was false.
Why is he not suing for defamation? Because he's a public figure. I hear that train a coming. Y'all got 2 weeks. Coming round the bend. Right? He's a public figure, and it's a parody, right? So he's suing for IIED. And the question is whether the First Amendment protects this sort of... Secondly, what's the other thing you can't... Why it's not defamation?
Because no reasonable person.
No reasonable person would believe it, right? No reasonable person would believe it. It's obviously false, right?
Great movie, by the way.
Is it funny? Yeah, it's pretty funny.
When I said it was great, I didn't say it was funny.
Well, you talking about the...
People versus Larry Flint.
Yeah, Larry Flint. Yeah. Okay? But the point is here that, and we talked about it last week, we want to stimulate the free flow of ideas. If we start cracking down on things like this, it will have a chilling effect, and the First Amendment needs more protection. Second full. Thus, while such a bad motive may be deemed controlling for purposes of tort liability in other areas of the law, we think the First Amendment prohibits such a result in the area of public debate about public figures. Were we to hold otherwise, there can be little doubt that political cartoonists and satirists would be subjected to damages or awards without any showing that their work falsely defamed its subject. Note 2 on 1044. Once the plaintiff is identified as a public figure and the speech is directed toward public debate in which the public figure is involved, the courts, consistent with the principal case, have permitted robust and vitriolic attack. Notice, last sentence, same page, it follows that the principal case does not protect the publisher or utterer of statement from liability where the attack is directed to a private individual in a matter of no public interest. And everybody knows, y'all know about Snyder v. Phelps, right? We all lived through that. And as much as it burns my you-know-what, I agree. All right? Again, everything you need to know about abuse of legal process is in what I handed you today. Okay? So don't skip it. If you have any questions, email me. Okay? It's not pretty straightforward. Okay?